record. Not, I will say, thank you so much for that. Google, Tim's saying, am I getting the record light now? Let me stop sharing for a second. Hello to everyone at home. One of your compatriots has just reminded me I wasn't recording, but I am now. So welcome. We're just kicking off on International Perspectives. And I just shared my messy screen, and we were just starting to talk about ACCC and Valve. And the fact that this case is kind of nice because it outlines a number of the issues that you get to come across in that final chapter that I've gotten you to read in Wilmot. And one of those issues was the Bonython test and the way that the court goes about determining the natural governing law of a contract. And the others have to do with, well, there was other discussion about the way that contracts can, to some extent, try and regulate what kind of legislation will apply to them in other jurisdictions by means of a choice of law clause. And Valve Corporation was trying to do exactly that, exactly those things. They were trying to argue that the natural law of the contracts that were formed between Steam, its subsidiary, and the Australian consumers, the natural law was in fact not Australian law at all, but it was the law of Washington State in the US. So it's not Washington, D.C., which is on the east-hand side of the US. It's Washington State, which is up in the kind of northwestern side of the US. And what we might do is have a little look at the case itself, because it's quite interesting. And I'll run up to the top there. If you have a little look, I might just move all your lovely faces over here so we can see. It has a look at some really nice issues that kind of interplay with things we've been looking at just last week and this week. So last week we finished off our discussion of Section 18 of the Australian Consumer Law, and in particular last week we had a look at the kinds of remedies that you could get under the ACL. Section 236 damages, 237/243 compensation orders, injunctions and so on. Hopefully by now you will have worked out that the ACL is an enormously powerful weapon. And up until this case was decided, it really wasn't certain how effective that legislation was in stopping people from contracting out of it. Okay, and in particular, the big grey area was online trading. Okay, and the even bigger grey area was online traders that were located in foreign jurisdictions. Whether or not the ACL would bite on their online conduct that was visible by Australian consumers. Okay, so did anybody of those people that managed to have a little look at the case, can you tell me a little bit of background? Anyone? Anyone happy to plunge forth? All right, let me just move my little chat box because it's hidden here. Valve had engaged in misleading or deceptive conduct and made false or misleading. Yes. In what context, Tim? What kinds of representations were made? Do you know? Some fairly basic ones. Representations to Australian consumers about their rights under consumer guarantees. Yes. Melissa says, in respect of refund of money for games. Diane says refunds. Yes. Keith says, oh, hello, Keith. Keith said Valve claimed there was no refunds under any circumstances and that they, Valve, were not, now it's disappeared, not responsible unless the individual had contacted the game developers. Tim says if customers buy a product online that's faulty, they're entitled to the same right to a repair, replacement or refund if they walked into a store. Yes, you're right, Tim. That's certainly the case clearly if the online trader is located in Australia. The issue that was unclear, as I was saying before, was whether the ACL would reach out and bite foreign traders, and it does, after this case anyway. So the big ticket items, if you go and have a look at, so here I am at, I might just take you to Steam because you can see what it's all about. It's an online gaming platform. Can everyone see that? So the usual suspects in terms of gaming fodder, things that you probably wouldn't encourage your children to play late at night right before bed. So you can see there's thousands and thousands of games on here. I think when this litigation was heard, there was about 4,000 different games that were available. But you can see, look at the price point there. They're all pretty cheap, aren't they? So what do you reckon the quality's like?
Not very good.
And there was some fairly unhappy consumers out there. Okay. Now, what Steam had said, I might just flip back to the, there's a little table in here, which is quite useful. So there was about 9 different representations that the ACCC complained about. And they were all in that typical American drafting. See if I can find it. It was up here somewhere. There we go. Look. All Steam fees are payable in advance and are not refundable in whole or in part. No refunds whatsoever for any reason, ever. And oh, by the way, we're going to put it in capitals because we're screaming at you. That's how much we mean that we're not going to ever give you your money back. So not surprising that the ACCC took objection to this. And as I said, there was about 9 different, there we go, 9 different representations. And some of them were made in the subscriber agreement. Some of them were made in a logged chat between a consumer and Steam that got fed up and just, wanted their money back. So no entitlement to refund. exclusions of statutory guarantees. So in their subscriber terms and conditions, in capitals again, in that lovely American style, they said, we hereby exclude all guarantees, warranties, blah, 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 as to everything, quality, purpose, everything. Then I think they started to represent that they excluded, so far as permissible, the statutory guarantees. They repeated the no refund policy a number of different times. No obligation where no recourse to a developer. So what they said is you have to go and try and get your refunds direct from the developer. It's none of our business. We don't care. You know, we're just the people that sold this to you. And so obviously the ACCC was fairly hot on all of this. And so it was quite interesting. The main issues there. So Valve Corporation is the head, is the main company that runs Steam, okay? The parent company to Steam. The representation that kicked off everything was this no refunds thing. Started to really tick some consumers off because of the low quality of the software. So the ACCC brings in good old Section 18 and throws in 29(1)(m) just for good measure. And the ACCC, this is where it cuts across our material for this week. The ACCC said that those provisions were applicable either because the representations were made in Australia, so the conduct occurred in Australia, or that Valve was carrying on a business within Australia, per Section 5(1)(g). Yes? So we fairly and squarely crop up against that issue of extraterritorial reach. Valve said that in terms of Section 67, and I'll take you to that because I think it's fairly important that you actually have an understanding of this. So you'll probably, from Contract A, just as a bit of background, you probably have come across Section 64 before, which is the one that normally gets bandied about in Contract A. Okay, so term of a contract is void to the extent that it purports to exclude, restrict or modify, or has the effect of excluding, restricting or modifying the application of all or any provisions of this division, or a right conferred by the provision, or liability of a person for failure to comply with a guarantee. So that's what you would have already probably seen. 67 is a bit of an extension of that. So if the proper law of a contract for the supply of goods or services would be the law of any part of Australia, but for a term that provides otherwise, or if a contract for the supply of goods or services contains a term that purports to substitute or has the effect of substituting the following provisions for all or any of the provisions of this division: the provisions of a law of a country other than Australia, or the provisions of a law of a state or territory, the provisions of this division apply despite that term. Now, give me your gut feel on the operation of this clause? What do you think it's intended to do? Yes, Tim, those terms can be extortionate. I agree. Ah, that's interesting. Okay. Tim says it's a jurisdictional matter. Protect the local person using local law. Interesting. Anyone else want to throw in their thoughts? If the law of a contract would be the law of any part of Australia, but for a term of the contract that provides otherwise, or if a contract contains a term that purports to substitute the provisions of another country's law, the provisions of this division apply despite that term. Sarah is saying comply with Australian law. So now we have in the student cohort a nice split in interpreting this provision that was essentially the split that happened in this case. If I'm reading Tim's interpretation right. Tim seems to be saying it's a jurisdictional matter and Australian law protects Australian people, but if the law of another country applies to the contract, we will leave that alone. Is that what you're saying, Tim, or am I putting words in your mouth? Yes, I'm putting words in your mouth, or yes, I summarised your position correctly. Leanne's saying regardless of the contract, the ACL applies, is how I understand. Keith says direct prevailing law to Australian law. Okay, so I did summarise Tim's position correctly. So basically, Tim has taken the Valve Corporation interpretation of this provision, and some others are taking, Sarah and Leanne are taking the ACCC's version of events. So either Valve's, just to kind of summarise Valve's position, what they were saying is that at first instance, it had been decided using the Bonython formulation. Can anyone tell me what the Bonython test involves? It's getting late, folks. I'm asking the hard questions. What does the Bonython, Keith's onto something here. Natural law of the contract.
So if I remember what I skimmed quickly, is there's the two limb tests. The first is what law the contract says applies, and then if it doesn't specify, then step 2 is it looks at the factors to ascertain what law should apply or what law the contract says applies, I guess.
Yes, absolutely, absolutely. So what Val's argument was, in terms of the second limb of the Bonython test, was that the closest and most natural association that this contract with consumers had, the closest and most natural association was with the law of Washington State in the United States of America. Okay? Parent company was there, almost all of its operations were there. Yes, they leased some service space, some rack space in Australia. That was fairly significant. I mean, it was worth over $1 million, that rack space here. But it did, that first instance decision did hold that the closest and most natural association of that contract was the law of Washington State. So Valve tried to stitch up a very nifty argument here. They said if the proper law of the contract is Washington State, then A doesn't apply. Okay? Because under the second limb, there's not a term that provides otherwise. We don't fall into that one. B, they say, can't apply to us. Yes, Tim, you're skipping forward. Just hold on to tick. B, they say, doesn't apply to us. How nifty is this little argument? Because they say, B says a contract for goods or services that purports to substitute the provisions of, for example, the law of Washington State. The provisions of this division apply despite that term. They say, hang on a minute, the contract has already been held to be a contract where the closest and most natural association is Washington State. So there's no substitution going on because the closest and most natural association is Washington State. So we don't fall inside B either. You see? It's a nice little argument, really. Do you think, for those that haven't read the case, that the courts were prepared to read down this provision in that manner? If the law of a contract, if the law of a contract would be the law of any part of Australia, but for a term that provides otherwise. Or if a contract contains a term that purports to substitute somewhere else's laws for ours, provisions of this division apply. What they are saying is the ACL applies to contracts where the closest and most natural association, the jurisdiction with the closest and most natural association is Australia. You're saying no, because it was unfair. Yes, it's against my gut feel. No, there was no indication there that the intention of the legislature should be read down in that fashion. And they had a good hard look at Section 64 and the breadth of Section 64. And they also had an interesting look at the fact that, I don't know if you've come across it in your travels in Contract A, but remember the old Trade Practices Act, the way that the consumer guarantees used to operate was by way of implication into a consumer's contract. So they would be implied terms. Those guarantees would be implied terms in the consumer's little contract itself rather than statutory guarantees, which they are now. And the court placed a lot of weight in the way that the ACL has streamlined everything and taken everything out of that whole mucky realm of implied terms and plopped it into something as straightforward as a statutory guarantee that can be directly enforced by consumers. It's meant to be simple. It's meant to be pretty much foolproof in terms of providing consumers with remedies. And there's nothing, if you go down, I think it was Leanne who originally said the way that it seems to just read is that if you have this attempt to invoke the jurisdiction of another country as your choice of law, it doesn't matter because the ACL will still apply. This is not a loophole that we want to leave open, was the court's conclusion on this one. But you can see, I just thought it was a very nice demonstration of the Bonython test and how it can be used in some fairly tricky legal argument, if you know what I mean. I think Val's argument was very ingenious, but ultimately unsuccessful, obviously. So they didn't get around Section 67. We'll just pop back to the case itself. Actually, no, we won't. We'll pop to my summary here. So the main issues were whether the ACL applied. Yes, it did. Whether Valve actually made the representations and the conduct occurred in Australia, and whether Valve carried on business in Australia. Now, what did the court hold in relation of those people that have had a little look at? Oh, sorry, Tim's saying something. This precedent confirms the ACCC's view that overseas-based companies selling to Australian consumers must abide by our laws. Yes, it absolutely does. It absolutely does. And Valve, the way that they ran this case, I mean, yes, they had a nice, tricky argument on Section 67, but the way they ran their case was just, it ticked off the first instance judge like you would not believe. Like, instead of, normally in litigation you can hone the number of issues down to a manageable level, and the trial judge basically says Valve wasn't having any of that. They weren't going to narrow anything. They took every single point. They conducted the trial much, I guess, as you would expect American litigation to be conducted. They took every single point that they could, and it just really ticked everybody off. And instead of it working in their favour, you can tell by midway through the first instance judgment it wasn't going to go well for Valve at all. And nevertheless, they appeal it up to the full court, federal court, and $3 million worth of penalty. There's a fair bit at stake. Appeal it up to the High Court. Well, they didn't appeal it up to the High Court. They sought special leave to appeal, and the special leave application was denied. Yeah. Must have been one heck of a commercial imperative for Valve. Yes. Well, $3 million is a fair whack, but if you can say then that they can trade in Australia with absolute reckless disregard for our consumer regime, what price is that? It's open slather almost really for them, isn't it? So yeah, the High Court application was denied. The $3 million penalty has stuck. And because the special leave application was denied, we now have these decisions in relation to whether the conduct occurred in Australia and whether the carrying on business, we have these 2 points now as fairly incontrovertible decisions now, authoritative decisions on how foreign traders will be treated by our ACL. So the conduct occurring in Australia was the website that was visible here. And if you look at, oh, this was all of their wonderful American drafting here. But you can see the attempt to exclude. Okay, limitations of liability. Disclaimers there. Expressly disclaims any warranty for Steam, software, merchandise. Here's your exclusion of your consumer guarantees. Any common law duties with regard to Steam. Just we exclude everything that we don't like, ever. implied warranties of merchantability, fitness for purpose, da-di-da-di-da. So they were obviously very, very intent on, and part of the reason I think for this is just the magnitude, getting back to what Keith said, the magnitude of their risk. Apart from the fact that there was a $3 million penalty at stake, there was over 2 million, even when this was heard a couple of years ago, there was over 2 million Australian subscriber accounts with Steam. So that's a lot of contracts if you think about it, Keith. And so, and I would say their business has only been trucking onward and upward. So that's a lot of contractual liability there that's potentially out there. And if consumers decide to take advantage of our ACL, that's potentially a lot of headaches for them. I think there was a large commercial imperative here. But that was the actual disclaimers. There's more. And if we go down here to about 101, so we start discussing things here. Where is it? What the judge basically says in relation to the appearance here. So the second issue was whether the primary judge erred in concluding that Valve made the representations here and thus engaged in conduct here so that the ACL could bite. So Valve went down on their argument that the ACL shouldn't bite by virtue of Section 67, and then it also argued that the conduct just didn't occur here, okay? The representations didn't occur here, and therefore the ACL didn't bite. How did they argue that? The usual. We're based beyond your borders. We are therefore out of your reach. And the website is an international website. It wasn't conduct that occurred here. The website was outwardly facing to all the world. Okay, it wasn't, you couldn't easily say that it was conduct that occurred here. There was a number of other things that, that was argued. But they talk about this number of different cases, Jackson and Spittle and distillers, and they rely on some of what was said in those cases. But essentially they say, I'm just trying to get here. There we go. We consider that where it's alleged the respondent has, by making representation, engaged in this sort of conduct, it's necessary to ask where. It's likely that representations here. If the respondent is based overseas and has a relationship with customers in Australia, it's likely that representations addressed to those customers will be taken to have been made in Australia, being the place where the customer accesses and reads the representations. So if you are making a representation, even though it's directed to all the world and it's online, if someone accesses it here, the representation will be effectively be repeated here. The conduct will be occurring here. And that's a fairly significant point that was always, as I said before, a grey area in this extraterritorial area reach of the ACL, the questions about extraterritorial reach of the ACL. The last point was whether or not they could be said to carry on business here. Can anyone, oh sorry Tim, I missed that last bit. So do Australian consumers still continue to use Valve Steam games? Yes, they do. They do, certainly they do. Whether Valve carried on, I would say most of the 2 million subscribers haven't even heard of this litigation, unless, you know, unless Steam has, you know, bagged the ACCC. Well, I don't think they'd be game to do so. Can anyone tell me how they were held to be carrying on business in Australia? I did mention it before. And for this reason, I think a lot of overseas, yes, yeah, Leanne, it was the servers. So they rented rack space here for, you know, efficiency in running the whole show. The rack space was worth about $26,000 a month, I think, all up, you know, 1.2 million odd dollars. And so even something as relatively minimal as renting rack space here can constitute carrying on business here. So very, very significant case in terms of extraterritorial reach. Tim has apparently some fairly significant talents in relation to flying sims. So that was just my take on the Valve case. Now have a little look at the result, what has happened to the Steam subscriber agreement. They've been pinged with this $3 million penalty. And now look at what Section 7 says.
AJ, I thought it was interesting that after, in the case, it actually says after the limitation of liability, if you're a resident of a European Union country, the above paragraph may not apply to you. Does that not suggest that they realise it doesn't apply in every country?
I'm sure that they've had similar stoushes elsewhere.
Yeah.
But I haven't specifically gone on a bit of a treasure hunt to find whether there's been litigation in the EU.
No.
I
Just
wouldn't.
they try and they put a specific clause in and then try and fight against it in another country.
And it's worth their, as I was saying before, it's more than likely worth their legal fees. Because if there's 2 million subscribers in our little country of 20-something million, or are we 30 million now? You know, there's going to be hundreds of millions of subscribers in the EU. And can you imagine if they could contract out of liability there? I mean, they can certainly contract out of liability in the US, because if you read that little article that I popped up for you, you will know that the American consumer protection regime is almost non-existent compared to ours. So that's where they're going to have obviously most of their subscribers, and they just go ahead and exclude everything. And you can for the US. So they just try and do that everywhere, and then they just try and put out the legal fires wherever they get lit. But now they seem to have learnt their lesson for us, and have a look at this. God bless all you Kiwis out there. Do we have any Kiwis in the chat tonight? They usually copy our legislation. So they figure, well, in for a penny, in for a pound. If we can't do it in Australia, well, we can't do it in New Zealand either. So effective action there by our consumer protection watchdog in an area that has been, like I said, of significant uncertainty for some years. Keith and Tim are currently debating the size of the gaming population, I think. Does anyone have any other comments or queries? I just thought this was a really interesting little case because it does tie together some of the things that we looked at in this last term of our little humble unit. And, you know, it gives you an idea about just how effective the ACL is. Comments, queries? I have finished up a little early, but I did want to try and get onto some exam prep. Before we do we have comments or queries in relation to the International Perspectives chapter? Queries in relation to... Oh, good on you, Tim. Tim saying, I quoted the ACL in my refund dispute with eBay and he won. Woohoo! See? ACL does it every time. I'm really super stoked about that particular decision. I think it was well fought by the ACCC. And you could just see, if you ever have a moment of insomnia and you wish to put yourself to sleep, go ahead and read that first instance decision, because you can just see the judge shaking his head going, oh my word, how to tick off a judge. Yeah, exactly. Okay, one last throw to you guys if you have any queries. You're all good with things like the Incoterms, what free on board is, what cost insurance freight is, all of that stuff. I don't need you to know all about the, you know, the conventions and things like that. In practice, I only had the Incoterms come up once, and that was in the late 90s. It's not something that comes up very often in practice at all, but it is very useful to know about choice of law clauses, and that is and how they operate. The Bonython tests, it's useful. I'm just talking about in practice here. It is useful to, even though choice of law clauses are normally in the boilerplate clauses at the end of a contract, it's always useful to go ahead and read that stuff, because sometimes there are some funky choice of law clauses that get put in there. Do we need this for the exam? Look, let me just grab the exam for you. One moment. 3, 1.
Good question, Sarah.
Deferred and supplementary. Deferred. I can't find, oh, here we go. Term 2. I can't find my copy. Normally, oh, here it is. Normally I do put in something little from this week. It's never in the actual large IRAC questions. So, yeah, there is something little tiny, the most tiny of tiny questions in the short answer question section. So let's move on then, shall we, to the standard exam. And the standard exam has similar format to what you would have encountered in contract A. So we have 2 parts, part A and a part B. There are, part A is the larger of the two sections, and that is worth a total of 30 marks. And part B, which is your short answer questions, is worth a total of 20 marks. Okay. In part A, part A, what I tried to do was give you a few little short answer-ish questions, even in part A, to try and give you a little bit of confidence before you come across the IRAC question. So there is question 1, A, B, and C that you need to answer in part A. And each of those questions are worth 3 marks each. The question 1 of part A in total is worth 9 marks. And you just want to jot those off in a few sentences or so. You certainly do not want to waste too much time on any of those questions. But I wanted you to turn your mind to those questions before you actually go ahead and think about writing out your IRAC. So your IRAC problem answer is in question 2. Question 2 does actually have 2 subparts. The first 2A is the big IRAC question, and that's 18 marks. And 2B is just a little, it's one last 3 marker, okay? So just recapping, part A, question 1, we have subparts A, B, and C. A, B, and C are worth 3 marks each. So that is total of 9 marks for question 1. Question 2, total of 21 marks. You've got the IRAC question is question 2A, 18 marks for that. And question 2B, just another little 3 marker. So that makes up your total 30 marks for that. Okay. Tyler, yeah, you wish. Part B, there are 7 or so questions, and they are all different marks, but no more than 4 for that section. So you've got like three questions that are worth 4 marks, 1 question that's worth 3 marks, 2 that are worth 2 marks, and 1 that's worth 1 little mark there. Okay. And that is the general structure of the exam. I will be releasing the actual contract clauses that you will need to consider for the IRAC question probably tomorrow, but certainly before the end of the week. Okay, so when you go into the exam, you will already have a knowledge of what the exam will generally look like. Part A, 30 marks. Part B, short answers, 20 marks. You will know that I want you to have a think about those, certainly those 3 short answer questions in Part A before you hit the big IRAC. Part A, okay, I need you to have answered those 3 questions before you try the IRAC. So don't just read through the problem and go straight to the IRAC, because you may well start to duplicate the things that I am asking you in those short answer questions, being question 1A, 1B, and 1C of Part A. All right? So do try those little shortish answer ones in part A before you do the IRAC. And then there's just one last little short 3-marker. Now, I've already told you many weeks ago that the IRAC question will be dealing heavily with termination. Okay? Anyone who comes into this exam without an excellent knowledge, nary I say mastery, of the area of termination will not probably pass this exam. All right? When termination occurs. Yes. Yeah, Keith. Termination. The issue of termination. When you can terminate and the case law that surrounds that termination and repudiation. So I need you, and this should come as no surprise. I've told you that, where are we? I have told you that Chevron Builders Licensing Board, you will need to know. Progressive Mailing House, you will need to know. At least those cases, at least. But more than that, if you want to really do well in the IRAC, you will need to know most of that reading material that we did on termination. You'll need to have a fairly convincing tour de force in your knowledge of termination for breach and repudiation. And that will become evident to you once you have started to look at those cases I've told you to look at. Bear in mind, they are only a starting point. They are not the be-all and end-all, okay, of the cases that you will need to look at in terms of that IRAC, okay? So, like I said, the information that you will need will come from that large chapter on termination for breach and repudiation. I can't make myself any more clear than that. Now let's have a look here. Sarah says, are we covering all weeks? No, you've asked me this question. Someone's asked me this question before. No, I can't usefully cover all weeks. I can't usefully cover all weeks. You know, I will be focusing to a significant extent on termination because, as I've said to you, and I make no apologies for that because that's one of the most practically useful things that you will ever know in terms of contract law. Yes, Sarah, I will come to that, my love. What is she going to tell us? I can feel the stress. Please, please, take a step back, breathe, have a cup of green tea. I will get you there. I will certainly get you there. I will go through the weeks that you will need to drill down into more next week because we've kind of run out of time. We are going to be spending essentially the whole next tutorial on exam preparation, but I think I have given you more than enough to go on with for this present point in time. What I will let you know, so you do know that there is a question in relation to the international perspective side of things, but it's really, it's just a very, very minor, the most minor of all minor questions there. You know that I've given you very focused readings only on that international chapter, and I make no bones about it. I think that the things that you need to take away from that chapter are things like the practical questions that tend to crop up, or in my experience anyway, that have cropped up in practice. So things like, the standardized terms like Bonython test, those kinds of things are practically useful. There is a question in the short answer section on illegality. There is a question in the short answer section in relation to the week that we did on restitutionary remedies. There is a question in relation to discharge by the chapter on discharge by performance and agreement that week that we did. There is a question in the short answer section on the calculation of damages. There is a question in the short answer section on frustration. And there is a question in the short answer section on equitable remedies. And you know that there is something on international. So they are the broad areas that you need to concentrate on for the short answer questions. Now, please, can I say, every single time I get people, they see a 4-mark question and they sacrifice their 18-mark IRAC for a series of 4-mark questions in the short answer section. Please do not do that. Tailor your responses in the short answer question accordingly. I have had people start on the short answer section and then leave themselves no time to complete their IRAC in part A. Please do not do this. Do not do this. Please start at part A and finish on part B. Okay? I would recommend that you spend no, the Sadleys are in this exam. Yeah. What if you developed an aversion? Oh, there's an antidote for that, and that's called end of contract law. So please do start at part A, finish at part B. Where there's only 4 marks, don't give me. I've had some people for a 4-mark question give me 3 pages because they finally hit on something that they know about and they just want to, yeah, all right, well, put it on the paper, Keith, and I'll mark it. I have had people give me a lot of words for the short answer questions because they just think, oh, this is finally something I know about, and then they don't restrain themselves and then proceed to answer all the other 4-mark questions. They just think, oh, woohoo, I finally found there's something that I can write about, and they just keep going and going and going and going, and to the prejudice of seemingly everything else. So please try and keep your wits about you with the exam. Keep an eye on the time, okay? And don't give me 3 pages for one 4-mark question. It's really, this is not the way to go. What is the way to go is calmly getting in there, everyone just taking a deep breath and marching in with some fairly comforting knowledge. The comforting knowledge is, you will have downloaded and hopefully printed the contract terms that you will be asked to advise on in the exam. You will be foolhardy in the extreme if you expect to not revise the contract clauses before the exam and still pass. There are a number of them, 1, 2, 3, 4, 5, 6, 7, 8 different clauses-ish. that are part of the contract that you will be advising on, and you will need to have looked at those clauses and at a minimum, very bare minimum, you will need to have read the cases I have suggested to you to read. Okay? So you will march into the exam with both of those pieces of pre-research having been done. You know what the structure is like. So all you need to do is look at what is effectively, there's about, apart from the actual contract terms that I'll release to you, there are about, I don't know, page and a half of facts. So all you need to really do is digest the facts and work out how they slot into your understanding of the case law and the contract clauses that you've been given. If you are smart, my suggestion to you is what some of the students did last term, and they went through the contract clauses that I pre-released for them. They went through that chapter on termination, and they started almost to hammer out their own IRAC on the basis of the information they already had given to them. So when they got into the exam, all they had to do was, as I said, slot in to their pre-prepared framework the actual analysis of the facts and how they bore upon the clauses that you'd already looked at, you had already looked at. Okay? So you should be able to do a fair amount of work on this prior to getting into the room. And as I've said to you before, I make no bones about this. I got this whole approach approved by the Dean because I think I feel as though it's a more authentic way as far as handwritten exams go, going in with at least having looked at the contract that you're being asked to advise on and being pre-armed with at least some of the relevant sections of law that you need to, the cases I'm talking about. There are no sections involved here, but the cases is a far more authentic way to assess what you know, I feel, anyway. And it should be more comforting to you because the more work you put into this assessment before the exam, the better off you will be in the exam. Okay? And as I said, those contract terms will be available to you before the end of the week. And that means that you will have time to look at them before we meet next week. And so if there are any questions that I can usefully answer in a very general sense in relation to the contract provisions that you've been provided, then we can talk about those then. But having said most of what I needed to say now next week today, what I need from you guys is to be very precise with how you come to the meeting next week. And if you have questions that you need answered, we will revert to more of a Q&A session. Okay? So you know how the lie of the land is now, and it's up to you to digest all that information and come and chat with me next week. I won't be providing answers. I have given you a very comprehensive set of guidances now. By the time you have the contract provisions you should have everything you need to do very well in this exam. Okay? I don't examine by ambush.
No, sorry, AJ, that's very comprehensive, and we really do appreciate it. The only further clarification, and in the interest of not ambushing, that I'd certainly ask for next week, is the split between common law and statute. The split between common law and ACL.
In the IRAC?
Yeah, in IRAC.
No, there is no ACL. I'm not examining the ACL in the IRAC. We have done the ACL. We have done the ACL to death.
Yes, that's been good, but it was so powerful. I expected that you would.
Expected it. Yes, I know. However, I would be remiss if I over-examined a particular component of the course. And I feel like we've done the ACL in week 3, week 10, and now we've looked at it for the oral submissions, which were 30%. Of that 30 marks, 15 were directly attributable to the ACL. So I feel like I have directly assessed that sufficiently now. We can lay that baby to rest. So you don't have to worry too much about that. It's really termination that I'm concerned with for the big IRAC section. What I can tell you of extra use is that let me just skip through here. In terms of the short answer questions for part A, the first short answer question, 1A, deals with further knowledge that surrounds the fact of being able to terminate or not. So it relates back to that same chapter. Question 1B, also 3 marks. It's more of the same, just probing a different aspect of termination. I'm just running through here. Yeah. And repudiation. Question 1C, again, 3 marks. Deals with issues of rectification. Question 2A is the big IRAC. You know what that's all about. Question 2B is just more on the issue of termination. And then I've given you the breakdown of the questions for the short answer section. So that, thanks, Tim. So you now have what you need. Please go away and make me very, very happy, because I want to see some standout performances here. And like I said, with downloading and printing out that set of contract terms and starting to pre-arrange your own little special IRAC framework, which I think you should be able to do, you really should be able to march into this quite confident. And from your performances in the orals, I'm very, very pleased with the way that this cohort is trucking along. Some of the best performances I've seen for quite some time, and by and large, like I said last week, across the board, I was very, very pleased. So what I am really hoping for is that you get those exam nerves under control, and you take me at my word. You march in there having done the preparation I've told you to do, and take your time, breathe, and read every question twice. Make sure that you understand what is being asked of you before you put pen to paper. Okay? So that's all I really need to say this week. And next week, what I want to see from you guys is a significant amount of work. If you can, I'm serious about this, if you can, it's really, tell all your friends. It will be really worth coming, okay? Come prepared with questions, and we'll try and allay your fears. But I want to do a Q&A session. I'm not going to be telling you the answers. I'll give you general advice and guidance. So it won't be a questions and answers session. It will be a questions and advice session. But I also want to go through exam technique, because there are a number of people that clearly haven't had a lot of experience with handwritten exams and are feeling a bit all at sea. So I want to go through good exam technique with you. Oh, thanks, Keith. You're a charmer. HD material. All right.
Absolutely. There are more than one way to skin a cat.
Are there any further questions? Are you all feeling a bit, please tell me, you're feeling a bit now. You're feeling a little bit more because I don't want you to stress about this stuff. You know, I know that there is some level of stress is inevitable, but and some is in fact useful, because adrenaline does actually help you think quickly and clearly. But what I don't want is people to just descend into that, you know, jumbled mess mindset. Okay, keep it controlled, people. Tim, thank you. You like my parrots? Yeah. eBay. No, it's not Japanese. It's eBay. It's Chinese. But I think it's effective anyway. I just wanted something that would make students feel calm. I'm birds. Go figure. They said calm to me. I don't know if they say calm to you, but anyway, that was my. Yes. You figure if we've done well in our assessments, we can breathe easy. Yes. Look, like I said, I don't assess by ambush. It's not worth it. It's not fun for me marking. You know what? I have to be honest, and this is purely selfish. I would rather sit down and mark 60 exams that were really spot on and where I could tell the student was just giving me their all after having prepared precisely and well, rather than make everything mystery, say everything's up for grabs, and get, 70, 67, however many exams I've got to mark of dribble. It's not worth it. Why? What's the point? So, I think most of you should be pretty happy with where you are, where you're sitting after the assignments. Now what you've got, the information you have. Join the dots. Make me proud, people, and come prepared next week for a really good session on exam technique and last few queries and pieces of advice I can give you. And thank you. Was it Leanne who corrected me at the very, 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 very beginning of the chat and said, shouldn't you press record now? All you people at home, send your gratuities to Leanne. because the session has now been recorded. I'm going to stop the recording now. Thanks, folks. Let me press stop and bye-bye to the people at home.